You're watching the legal breakdown. So, Glenn, we've got potential news on Trump's DC trial date. That date is slated for March 4th, 2024, but there's been reporting that the trial date might be moving back. Do you agree with this assertion?
I don't think there's any indication yet that the March 4 trial date will not hold. We did get a new ruling from Judge Chutkan. You may remember, Brian, and we talked about this on an earlier legal breakdown. Donald Trump's lawyers filed what I think can accurately be characterized as an hysterical motion, saying, Judge, even though this case is on appeal, the absolute immunity issue is on appeal, so there's really nothing going on in the trial court. They're still giving us evidence. They're turning over discovery, and they gave us an exhibit list and they filed the motion, none of which required the defense team to do anything.
Right.
There were no deadlines to be met. But based on those assertions, what Jack Smith's team was doing by giving them more evidence, they said, we want you to hold them in contempt. We want you to sanction them. We want them to be fined. We want you to call them bad names. Okay, I made the bad names part up, but they wanted the judge to rule that Jack Smith and his team had intentionally violated a court order, providing that no additional evidence can be given to the defense team. Well, we just got a ruling very short time ago from Judge Chutkan saying, no, they didn't violate any court order. They didn't violate any ruling by simply giving you stuff. They are allowed to give you discovery. They're allowed to give you an exhibit list. Why? Because there's nothing for you to do. There's no deadline for you to meet. The only little sliver where she agreed with the defense is she said, okay, I'm going to say that they shouldn't file any more motions, even though you don't have to respond to them unless they ask permission of the court first. But in substance, Brian, Judge Chutkan kind of told the defense team, just talk to the hand. So, I don't think we can glean from that 6-page ruling that was just issued by Judge Chutkan anything about the March 4 trial date, whether it will stick, whether it might slide. There are other things from which we can, glean whether it remains a realistic trial date, but really nothing based on the motion or the order that was just issued by Judge Chutkan.
And by the way, Trump's team pretty much gave the game away by getting so upset that that they were being given filings that they didn't even have to do anything with, because it really shows that the whole point of this was just to achieve delay, to the point where they would get upset that anything is happening, even if it's just like any semblance, any indication that this case is moving forward is enough for them to try to get Jack Smith held in contempt. And it really does put on full display the whole point of this, which was they want a delay, they want nothing to move forward, and even the smallest thing is going to be grounds for them to try to like throw a wrench into the whole case.
You're exactly right. That was a tell. They might as well have captioned the motion, hysterical motion for as much delay as we can get, because that really was the substance of that motion.
Given the urgency of this case to move forward, do you believe the Supreme Court will move quickly on this question? Like, where are we in this whole process of the Supreme Court adjudicating the question of immunity?
Things have been moving pretty quickly, but we're a little bogged down at the moment. Here's where we are, and here's where I think we're headed. The absolute immunity nonsensical claim, you might as well say that a president has magical unicorn immunity. The absolute immunity issue was argued to a 3-judge panel of the DC Federal Circuit Court of Appeals, and we're waiting for a decision. I mean, pretty much everybody who knows anything about the law believes the decision will be a president is not a king. He's not above the law, and he doesn't have absolute immunity, but we have to wait for that opinion. And then there are 2 things that will happen. One, Donald Trump will ask the full appellate court, we call it en banc review, all judges to review the decision by the 3-judge panel. And then after that, assuming that the court rejects en banc review, Donald Trump will inevitably seek to have the Supreme Court review what we expect to be the denial of the absolute immunity claim. My belief is that the Supreme Court will refuse to accept it for review, which will mean it'll be given back to Judge Chutkan and we will be back on the trial track. What we can't predict is how quickly all of that might happen.
Why might the full DC appeals court, the Circuit Court of Appeals, why might they reject en banc review? Is it because they might agree with the three-judge panel, and so there's no need to bring this to the full court?
Exactly. It's important to keep in mind that when Donald Trump's lawyers say a president has absolute immunity, he can commit any and all crimes while in office that he wants, and the law can't touch him. He can't be prosecuted. There is absolutely no law. There's no federal statute that grants a president that kind of immunity. There is no appellate law. There's no case law. No decision has ever been handed down by any appellate court in the land, including the Supreme Court, saying, yeah, absolute presidential immunity is a thing. And third, the Constitution has absolutely no provision regarding presidential immunity. There's no constitutional support. So given that there is no support in those three sources of law for the notion of absolute immunity for a criminal president, there's no reason for the full appellate court to take this up. There's no reason for the Supreme Court to take it up, which doesn't necessarily answer the question, will the Supreme Court take it up? Perhaps for other reasons?
Right. Well, there are a lot of Republican lawmakers whose heads are up Donald Trump's ass, but I don't think that's enough legal justification for any of these courts to actually take up this question. Glenn, once we get an answer from the Supreme Court on the immunity question, is there anything then stopping Judge Chutkan from quickly moving forward and getting this trial going?
Nothing. So at that point, assuming the Supreme Court says either we're not going to hear the case, Judge Chutkan, it's yours again, or we are going to hear the case and we decide there's no such thing as absolute presidential immunity. Here, Judge Chutkan, it's your case again. That's when we are back on track to get to trial. Now, Brian, if I had to guess, from the time Judge Chutkan gets the case back, I would suspect we're still going to see a couple of months of lead time. At that point, the March trial date, March 4, may not be viable. It may be we see a trial date more along the lines of May. But I still think once Judge Chutkan gets her hands back on this case, there's still some litigating that needs to be done. There's some outstanding motions. There are some issues to be vetted. Of course, a jury has to be selected. That will take some time. So, I think once she gets it back in her court, Judge Chutkan will probably give the defendant, the parties, but primarily Donald Trump and his defense team, a couple of months to gear up and get ready to go to trial.
Glenn, if I'm not mistaken, the Florida case is currently scheduled for May of 24. Is that correct?
It is May 20th. And here's the thing, there's a hearing in that case on March 1st. Judge Cannon is calling the parties in, and they're going to talk about the viability of that May 20 trial date. Keep your eye out for that trial date to be vacated, to be canceled, and for Judge Cannon to push that trial date well into the future. That's what I have a feeling will end up happening on March 1st.
Okay, and then in that case, even if this DC prosecution is forced to be pushed back by virtue of waiting for the Supreme Court to rule on the question of immunity, that could still take that place, because if that Florida trial is vacated, then all of a sudden we have a whole block of time that's suddenly available for the DC prosecution.
You're absolutely right. That could happen, given who Judge Cannon is. She has shown herself not to be all that fair and independent and impartial. She's been ruling Donald Trump's way in on matters that don't seem quite right to experienced litigators. I think it unlikely she's going to say, oh, okay, the March trial date up in DC got canceled. Let's go ahead and hold your feet to the fire for our May 20th trial date. But here's the outlier that I would keep your eye on. There's another criminal trial up in New York scheduled for March 25th. It could be, if the DC March 4 trial date gets canceled, then maybe that late March trial date in New York can slide in, and the New York judge can order Donald Trump to go to trial in that case at the end of March.
Okay, well, these are problems that only Donald Trump has right now. So, Glenn, let's finish off with this. Trump himself has been doubling, tripling, quadrupling down on this claim that a president has to have full immunity, obviously, to protect himself. Most recently, he posted on Truth Social that, quote, even events that cross the line must fall under total immunity or it will be years of trauma trying to determine good from bad. Can I have your reaction to that line in particular, where he kind of gives the game away and admits that what he did was over the line, but that regardless, he still needs immunity?
Yeah, it's an interesting choice of words. You know, if Donald Trump's lips are moving, he's probably confessing to something. If Donald Trump is posting something on social media, there's a good chance it's incriminating, right? That's who Donald Trump is. So when he just posted, a president has to have absolute immunity even when he crosses the line. Now, he obviously didn't affirmatively assert, I crossed the line. So it's what we prosecutors call a tacit admission or an implied admission. Because if there's one thing we know about Donald Trump, he's not talking about protecting other presidents
Right.
who may have crossed the line or who may cross the line in the future. He is basically giving up the ghost, saying, yeah, I crossed the line, but I need absolute immunity for all of my crimes. He wants to commit crimes and he wants those crimes to be completely excused. That's how I read that most recent Donald Trump post. The thing is, Jack Smith has so many confessions, so many incriminating statements, so many statements against interest by Donald Trump. You know, he's going to get to pick and choose which are the most directly and sharply incriminating. And I think this one, because, you know, it's a little bit vague, it's a little bit hypothetical, it's not a direct assertion that I committed crime like some of his other posts and statements are, that Jack Smith will put an exhibit sticker on it. He'll put it in the file and he may pull it out and introduce it at one or more of Donald Trump's trials, but he may not.
Yeah, I mean, the point is that he's doing himself no favors every time he opens his mouth or logs on to Truth Social. So, with that said, we will obviously keep a close eye on whatever happens with both the trial date in this March 4th D.C. prosecution, as well as the Supreme Court's ultimate decision in this question of immunity for Donald Trump. So, for everybody watching, if you want to follow along with this, please make sure to subscribe. The links to both of our channels are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.